We're back. There's a lot going on, like always. Look, let's ease back into things, okay? Let's ease back into all things ocean shipping, supply chain, regulatory stuff. What's going on out there? Look, today's a mixed bag. I'm going to break it down for you. By Land and by Sea is back to help you sort through the noise and understand it all in real people speak. Welcome back. We're back. Hi, welcome to By Land and by Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor. That's me. I'm Lauren Beagen, founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics and the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. So before we get into the discussion of the day, let's go through my top 3 stories of the week. All right, so story number 1, we're jumping right in. Look, we haven't had any language come out of the final rule from the FMC, the Federal Maritime Commission, on the unreasonable refusal to deal or negotiate with respect to vessel space accommodation. So that was the first of the rules that the FMC tackled under OSRA. Remember, there were 3 rules. So let's shake off all the cobwebs. Let's start over here. So the Ocean Shipping Reform Act of 2022, OSRA 22. We talked about it so much. We've talked about it so much on this show. Go back and check the old episodes if you want to really dive into it. But it was passed on June 16th, 2022. So just over 6 months ago. Had a very long to-do list for the FMC. And 3 of the things that were on the to-do list were rulemakings. The first one was unreasonable refusal to deal or negotiate with respect to vessel space accommodations. The second one was the D&D, detention, demurrage, prohibited practices. And the third one that we're actually still waiting on some language for, or some sort of movement from the FMC, is the unfair, unjustly discriminatory methods. That one I'm so interested to see, because that one is going to be really hitting on some of this bad acting. And the FMC has started to come out very strongly, basically saying, look, you cannot retaliate against somebody who's going to be filing a complaint against you. And you should just be a better person in general, is kind of what they're saying across the board in terms of supply chain. But so those are the 3 rules. So the first rule, that's unreasonable refusal to deal or negotiate with respect to vessel space, was required to be finalized within 6 months. And so 6 months from June 16th is December 16th. So we are now at January 6th, where you had the holidays. Maybe next week we'll get the language. I mean, so it's a sliding scale. So they missed the deadline of December 16th. Maybe they didn't. Maybe we're going to see somewhere, but it wasn't published on their website. It certainly wasn't published on their docket log. I haven't seen it published anywhere. So if anybody has seen that language, that final rule language, please send it over to me. But I'm keeping an eye on it, and I have not seen it. So this is the interesting one. This unreasonable refusal to deal or negotiate with respect to vessel space. This dealt with the categorical exclusion of cargo. Particularly, they were looking at the imports versus exports. Remember when everybody was getting $20,000 for a box coming from China to the West Coast? They weren't necessarily waiting for the exports because they were small bucks compared to the big bucks that were coming in on the imports. That's what that rule kind of tackles. It looks at categorical exclusions on exports, or just general categorical exclusions, this refusal to deal or negotiate with respect to vessel space. There was some language in there that talked about business practices and business rationale, and you can still exclude or deny or refuse to deal for certain instances if that's part of your kind of overall mission of your business. But then there was some talk in the comments about the comments that were filed. Well, what does that mean? Does that mean we need to file this new business report? Does that mean that that's something that, is that an actual official document? Do we need to file it with the FMC, or is it just kind of a general notion? It was a little soft in the language there. I think that the case law really will fill in, and I think that maybe that's what the FMC was hoping. But I think we're going to see a little bit of clarity, specifically on that area. But in general, it was supported. I think that the comments really supported this unreasonable refusal to deal and negotiate when the FMC was basically saying categorical exemptions or categorical, refusals are going to be categorically unreasonable. So we're still waiting. No language on that. All right. So story number 2. This one's kind of a big one. I don't know if you guys saw this, but just yesterday, the Federal Trade Commission, the FTC, published a rule, published a rule or a notice of proposed rulemaking about non-competes. So non-competes has been a major story in a lot of industries, but certainly kind of maybe in the past year and a half. I've been seeing it really take wing in the freight industry. So I suggest that you follow Matthew Leffler if you don't already. He's the armchair attorney. He talks about non-competes quite a bit. He talks about, ways of kind of strategies for negotiating around non-competes or he's spoiler alert, he's against non-competes, as I think a lot of us are. But I've also been really interested following Steam Logistics and specifically Steve Cox, the president of Steam Logistics on this. Steam has come out swinging against non-competes as well. Okay, so what's going on here? So let's kind of break it down. So this is the Federal Trade Commission. So we talk a lot about the Federal Maritime Commission here on By Land and By Sea. You might kind of recognize this is also a commission. So what does that mean? So the Federal Trade Commission. So this is like the FMC because it is a commission. So that means it's not an executive branch agency. So like Department of Transportation is a cabinet level agency. That's a secretary, and that's Secretary Pete Buttigieg, kind of appointed by the president to fill that role. Commissions are a little bit different. They're independent regulatory agencies. DOT is not an independent regulatory agency. They take their directives from the president's office for the most part. I mean, this is an oversimplification. But so the commissions are a little bit insulated from all of the politics of it all. They're independent. So the FTC, the Federal Trade Commission, is an independent commission, similar to the FMC, the Federal Maritime Commission that we talk about a lot, independent regulatory agency. So the FTC, just like the FMC, has 5 commissioners. Or they're allotted 5 commissioners. It actually looks like they only have 4 commissioners right now, according to their website, which is strange to see, not uncommon. It happens a lot. Sometimes these commissions, because they're independent, don't always get all of the attention, especially from the executive offices, that they maybe deserve. I mean, the FTC, the Federal Trade Commission, that seems like a big agency, right? I mean, we're all familiar with the FTC, and they only have 4 commissioners of the 5 that they're allotted. I mean, not big news, just interesting to note. They actually serve 7-year terms. So the FMC, the Federal Maritime Commission, has 5-year terms. This FTC, the Federal Trade Commission, has 7-year terms. Just interesting. Maybe that's why we don't have a commissioner, because it's not with the 5-year terms of the 5 commissioners of the FMC. As one's leaving, kind of one is on deck to come in. That often kind of is how it works, because you have every year basically a turnover of somebody. Whereas the FTC, every 7 years, it's not every year that you'd have somebody being turned over. So so they serve 7 years. I just thought that was interesting with the FTC. So what do they do? What does the FTC? And like I said, we're just kind of breaking this down so that we can kind of get acclimated, familiarized with the FTC. So their mission, similar to the FMC again, the Federal Trade Commission, their mission is protecting the public from deceptive or unfair business practices and from unfair methods of competition. They say through law enforcement, advocacy, research, and education. I love that they kind of outline those 4 different areas of how they do it. They say law enforcement, advocacy, research, and education. But I mean, doesn't that sound very similar to the FMC, the Federal Maritime Commission? This FTC, their mission, protecting the public from deceptive or unfair business practices. And that's basically a page out of the FMC's mission statement. And from unfair methods of competition. Again, that's similar to what the FMC does. Although the FMC, like we talked many times, ocean-borne cargo transit. So the FTC is kind of subject matter neutral there. It's just deceptive or unfair business practices or unfair methods of competition. So the FTC, the Federal Trade Commission, their vision is a vibrant economy fueled by fair competition and an empowered, informed public. I love that. That's what we're all about here at By Land and By Sea at the Maritime Professor. We want everybody who's in the industry to be empowered and informed. This is kind of murky stuff, and that's why I like to kind of break it down and real people speak, because if only the lawyers are talking to the other lawyers, nobody's really going to benefit, right? I mean, you need it to be just regular people speak. And so I love that the FTC says that a vibrant economy fueled by fair competition and an empowered, informed public. So the strategic goals of the FTC: protect the public from unfair or deceptive acts or practices in the marketplace, protect the public from unfair methods of competition in the marketplace, and promote fair competition, and advance the FTC's effectiveness and performance. So, I mean, there are two out of the three goals are protecting the public. And then the third one is just making sure that the FTC can do that, and advancing the FTC's effectiveness and performance. Look, this all sounds similar to the FMC, right? I mean, we keep drawing these parallels. Like I said, the FMC, the Federal Maritime Commission, is for ocean-borne cargo. But these FTC, these commissions, these general commissions, they're big deals. I mean, we see the Securities and Exchange Commission, that's a commission. Federal Energy Regulatory Commission, that's a commission. So these commissions, independent regulatory agencies, they're independent, so they're not supposed to be beholden to the roller coaster of politics. Especially with the FTC here, with these 7-year terms, they're more insulated from the politics. I mean, think about it. Like, generally, American politics goes in 4 years, 2-year, 4-year terms. So the FMC having only 5 years, they're just kind of outside of that bubble. 7-year terms, I mean, that's a presidential term almost. I mean, that's 7 years for a commissioner to be on at the FTC. It's a long time. That's kind of cool. I like that. I mean, it gives a little bit more staying power. It gives them a little bit more. They get their feet wet. They dive in. I mean, it takes a couple years to kind of, if we're not already in the industry, or not already, even if you're in the industry, it takes some years to get up to speed on kind of like, what can the FMC do? What can't the FMC do? And so to become a commissioner and to be in that role, FTC, FMC, whatever the commission is, I love that 7 years because it gives them time to get their feet wet, get comfortable, and then really start making some differences. So the FTC is the only federal agency with both consumer protection and competition jurisdiction in broad sectors of the economy. Basically, they're saying, look, we do consumer protection and competition jurisdiction. We protect, kind of business competition. The FTC pursues vigorous and effective law enforcement, advances consumers' interests by sharing its expertise with federal and state legislatures and U.S. and international government agencies. Sure, because that's their role. They're supposed to be part of this competition world of all business. And so they want to, and I love that they're outlining this in their kind of about me section. They're basically saying, look, we want to share this knowledge. We want to make sure that it's not just this federal action, but our international partners are kind of seeing things the same way, or at least seeing what we're doing. And also the state legislatures are kind of on board, or, different jurisdictions, but like showing them, look, this is what we're seeing in case states have specific needs for some of that stuff. So continuing on, they also develop policy and research tools through hearings, workshops, and conferences, which basically means that they're outreaching into the public. They create practical and plain language education programs for consumers and businesses. I'm going to take a look. I think that they probably do have some pretty good webinars on their website. I've loved what I've been looking at, just like past couple days since they published this rule. But I want to know a little bit more about the FTC. So they have different bureaus, the same way the FMC, the Federal Maritime Commission, has different bureaus. The bureaus at the FTC are consumer protection, competition, and economics. They also have an office of the General Counsel, of course, and they have 8 regional offices. I love it when commissions have regional offices because that means that they're out in the field really getting their hands dirty and kind of absorbing what's going on at a more boots on the dock, boots on the ground level. The FTC was actually created in 1914 to prevent unfair methods of competition in commerce as part of the battle to bust the trusts, is what they say. Over the years, Congress has passed additional laws giving them broader authority. And now, as we know, they kind of have taken on the competition, the Federal Trade Competition role, or Federal Trade Commission. They do the competition of the businesses. Okay, so that's all the background. So that's who the FTC is, but what are they actually doing here? Why did I even bring them up? This is a long story number 2 of the day. So they just published this Notice of Proposed Rulemaking, this NPRM. Remember, we've talked about this a lot, different rulemaking levels that happen in the federal government. The ANPRM, the Advanced Notice of Proposed Rulemaking, is kind of when an agency's like, we're not really sure. We have some thoughts. We'd love to get the industry's feedback. So they might submit some questions. They might have some maybe draft language, but that's kind of a pre-stage. FTC didn't go there. They went straight for it. They said, look, we have some language ready. We're going to throw this out there as a notice of proposed rulemaking. And so that's what they did. They put together some language. They have a whole new subpart that they'd like to include in their regulations that talk about non-competes. And so that's what this is. It's an NPRM, a notice of proposed rulemaking, to ban non-compete clauses. The next stage will be, or could be, the final rule, depending on what comments are filed. And then that final rule, I mean, if they don't get, I can't imagine that they wouldn't get adverse comments, but if they didn't get any adverse comments, it could be effective on publication, the next stage, the final rule. Probably not. They're probably going to have a 30, maybe 60-day effective date. So we have now notice of proposed rulemaking. You'll have 60 days to comment. They'll collect all those comments, and then we'll go over to the final rule. And then they'll have maybe 30, 60 days to collect any comments. And they're only going to stop the train at that point if there's big comments, big discussion, big things that they forgot or missed or kind of warrant the stopping of that train. But really, this is your moment. This notice of proposed rulemaking, this is your moment to submit your comments if you have thoughts on non-competes. They want to hear about it. This is the time. This is the most appropriate time in the rule-making process that they're going to be moving forward with, this notice of proposed rulemaking. So that's what it is. They published this notice of proposed rulemaking, this NPRM, to ban non-competes, saying that they hurt workers and harm competition. Look, I think this is great. I don't know if you've actually been following Haley Page at all. So she's a wedding dress designer, or used to be a wedding dress designer, but she's been iced out of even actually being able to use her name in public because of restrictive clauses in agreements that she previously filed or signed when she was first signing on as a young dressmaker. So for anybody who's basically bought a wedding dress in the past 10 years, you're going to know who Haley Page is. She's like sparkly and all the frills. So she basically can't be working in wedding. And I don't know all the specifics of hers, but she can't even use her name. She can't use her public name. She's had to rename herself in the public eye, Squall. She can't, I was like, what was her name? Haley Page. I had to look her up just to make sure that I had gotten her name right. I mean, she hasn't even been out of the industry that long. I'm sure that's all around non-competes. I mean, this is a big deal. This changes people's lives. Just to protect a little bit of business stuff, you can basically eliminate people from industries. It just seems too big. Somebody actually described it recently as basically the most broad daylight monopoly or antitrust violation out there. This is so interesting. I'm really jazzed about this rule being published. So the rule is now open for comments. It's going to be published in the Federal Register in the next few days. Remember, there's always a lag between agency publishing it. So the FTC put it up just yesterday, January 5th. The Federal Register, that's kind of the classified section of the U.S. government's like newspaper, online newspaper. That's where if you have to like publish it in a public way, on behalf of the agency or behalf of the federal government, that's where it goes. So it takes just shy of a week usually. So I'm expecting probably Tuesday maybe. Came out on a Thursday. Yeah, Tuesday, Wednesday. So once it hits that Federal Register, you have 60 days to get your comments in from there. So really you're looking at maybe 63 days right now. Look, people are in general going to be against non-competes, right? But like, look, as a business owner now, it has me kind of thinking, what about the C-suite level position? So people move from company to company and they can't just unlearn the business secrets that they might have learned while they were with that company. There is some validity to that argument, but let me be clear. Look, let me be very clear. I am against non-competes. I don't think that they serve the purpose, and certainly their application these days is way too wildly broad. But I was discussing this back and forth with Matt Leffler on his LinkedIn post earlier today, and he was really kind of illuminating the fact that there is an exception to that rule, into the rule published by the FTC. So he basically said, copying from the FTC's rulemaking, a person who is selling a business entity or otherwise disposing of all of the person's ownership interest in the business entity, or by a person who is selling all or substantially all of a business entity's operating assets. So that's the exception. Okay, so basically we're talking about ownership interests, and that's where the exception is. You can still maybe have a non-compete, and I have to look at the language specifically, but it was kind of an interesting back and forth. So that's when I started thinking, well, what about shareholders or partners? That often happens, especially in law firms. People kind of keep rising up the ranks, but then they get to become part owners. So Matt and I kind of got to talking about it over messaging here or over comments on his LinkedIn post. Matt basically was saying owners are the ones that are not exempt. So the proposed rule defines the terms as substantial owner, substantial member, and substantial partner, meaning an owner, member, or partner holding at least 25% ownership interest in a business entity. So in essence, the proposed rule will permit a non-compete to remain for the sale of a business as it relates to substantial owners. Okay, so I think 25% is an interesting threshold, right? So a substantial owners, 25%. I'm going to have to go back and read the text of this rule. I want to dive into this a little bit more. I think that this is going to be really interesting to see the comments that are coming in here. This will likely have a lot of interest. I mean, obviously, it's not just freight. It's wedding dresses. It's every industry out there, right? It's all business. So don't be surprised if we see hundreds, if not thousands, of comments filed on this. But I'm interested to see comments specifically for this exception, this 25% threshold. Is that too high? Is that too low? How do they balance the fear of basically high-level business secrets from like a CEO leaving and working for a competitor? That's the stuff that I'm interested in here, because I think that's where the broadness of non-competes, everybody can get around and say, no, that's not right. But this specificity, there is a little bit of like, I don't know, I guess my immediate thought was, well, what if somebody goes from Pepsi to Coke? And they take that little like, I don't know, there's a little chemical difference, and you know what I mean? Like what happens if that type of IP, there's probably protections around the IP itself, but that's where the non-competes, the original intent or the kind of the justifiable intent seem to be. How is that addressed? So that was a very long story number 2 of the week. But here we go. Story number 3. Let's keep moving. Story number 3. A National Maritime Strategy is now directed by Congress to be created. A National Maritime Strategy. We've been trying to do this for years, right? Okay, so the National Defense Authorization Act, the NDAA, was approved by Congress last month, December 15th, and it went to the president's desk for signature. And so there was a lot of interesting stuff in the National Defense Authorization Act. So this is kind of one of those like surefire bills, happens every December, basically. And as it suggests, the National Defense Authorization Act, there's a lot of kind of military spending in there, but of course, with all bills, there's some other stuff. And so some of the other stuff related to maritime. So of course, I perked up and I was like, what's in there? So one of the sections, one of the things that the act directs is for the U.S. Department of Transportation, in consultation with the U.S. Coast Guard, U.S. Transportation Command, U.S. Transcom, to submit to the House of Representatives Committee on Transportation and Infrastructure, T&I Committee, and to the U.S. Senate, the Committee on Commerce, Science, and Transportation, a National Maritime Strategy. So this is interesting that they are basically strictly saying, we need to get this scooting. We need an actual National Maritime Strategy. So, like I said, a National Maritime Strategy has actually been attempted in a few forms previously. But the additionally interesting directive here is that the NDAA, the National Defense Authorization Act, is also directing that the National Maritime Strategy be updated not less often than every 5 years after the submission of such strategy. They want staying power. They want this to not just be one effort that gets worked on for a little bit and then everybody kind of burns out and then everyone's like, oh, I don't want to look at it again. They want this to be every 5 years. They want this to become part of the fabric of the national strategy, to have a national maritime strategy. It was interesting. In the actual act, they talk about what information they actually want in the National Maritime Strategy. And so I'm going to read parts of these. So things that the strategy is required to have includes international policies and federal regulations and policies that reduce the competitiveness. So identifying what some of these are, identifying the impact of reduced cargo flow due to restrictions in the number of members of armed forces stationed or deployed outside the U.S., and then make some recommendations to U.S. documented vessels more competitive in shipping routes between the U.S. and foreign ports, increase the use of U.S. documented vessels to carry cargo imported to and exported from the U.S. So I should kind of clarify this a little bit here. The U.S. has a U.S. flag fleet, and that's kind of supported by the Jones Act. The Jones Act we've talked about before, but essentially it's U.S. owned, U.S. manned, U.S. flagged vessels that are the only ones that are allowed to be servicing domestic to domestic ports. And so part of that is for national security. Part of that is for the promotion of the U.S. flag fleet. Having a national flag fleet is going to be supportive of readiness for, if we have emergency situations or militarily or otherwise. And so we have this basically policy, this Jones Act policy that really helps support and promote the U.S. flag fleet, but we don't have a lot of funding. We don't have a lot of direction. And there's a little bit of kind of a disconnect there. I believe it was in the 80s that we kind of changed some of our funding of the programs. And so this shipbuilding, this robust shipbuilding that we used to have isn't as robust as it could be and should be, really. So now that's kind of what this national strategy is all about, is kind of how do we build up our U.S. presence, our U.S. documented vessels, flagged vessels, and how do we become competitive? So I realize I should have said that right off the bat, but that's what a U.S. National Maritime Strategy kind of is all about. Is like, how do we become competitive as a new U.S., like as a maritime nation? So other things that they want addressed, Congress wants addressed in this National Maritime Strategy: enhancing U.S. shipbuilding capability, like I said. Increase the use of short sea transportation routes. So that's kind of like the shorter routes, including routes designated under section. Okay, so to enhance intermodal freight movement. So sometimes if you can get some of the cargo off the roads and you can put them on barges and have them move that way, then, it helps rush hour. It helps the truckers sometimes because they don't want to be sitting in some of those bad. It moves them to kind of more well-positioned areas that might not have that congestion, and then you can move it from there. Enhance workforce training and recruitment of the maritime workforce, including training in innovative physical and information technologies. Increase the resilience of ports and the maritime transportation system. That's always a good thing, increasing the money that goes to the ports. Increase carriage of government-impelled cargo on U.S. flag vessels. This is all just kind of moving around, trying to bolster the U.S. flag fleet and the U.S. maritime presence through our ports as well. Not a bad thing. And we should have a very specific strategy. We should have a strategy at all. We don't. We should have a clear maritime strategy. And I love that they're saying we should be revisiting it every 5 years to make sure that it's updated. Love it. I think that's great. Okay. Those were the top 3 stories of the day. We're just getting into it. So what I wanted to cover today was actually just looking through some of the detention demurrage posts that we previously were looking at. We're only going to hit one today because we're already well into our time. So let's get into the meat and potatoes of the day. So the FMC released their detention demurrage rule on October 13th, and it closed on December 13th. That's a 60-day comment window. We've gone into detail on this detention demurrage, notice of proposed rulemaking. So it's an NPRM. This is what the FMC stage is at. We had the ANPRM last spring, April 2022. And then October, we had the D&D, the detention demurrage notice of proposed rulemaking. So they proposed some language that they want to put forward for their final rule. This comment period that the FMC put out starting October, ending December, was kind of like, there, you'll probably have one more bite at the apple, but really that was the moment. So there's still some late filed comments that were still being filed after the the December 13th filing. But look, there's almost 200 comments filed here. I've been walking through them all. Some of the highlights of what was happening that the D&D rule kind of highlighted. It was streamlining contractual relationships for invoice payments, basically saying only those who actually know everything about it should be beholden to being required to pay for the invoices, basically saying motor carriers were going to be taken out of the responsible party list, but they may pay, but they weren't going to be required to pay. The FMC also introduced a 30-day requirement for invoices to be issued after detention demurrage had concluded, and then a 30-day requirement to pay it after you receive the invoice to kind of keep everybody honest. I've talked about that before. There's a little bit of trouble with that 30-day invoicing requirement post D&D because a lot of places require that you actually pay before they release the cargo. And they could even be holding up cargo that's not associated with that invoice because of delinquency of payment because, okay, they say it's available on Tuesday. on Wednesday, you file a dispute against it. And so now basically all your cargo, whether it's at that port or not, is going to be held up because now you're delinquent because you were late one day. But you're actually just trying to dispute it. That's one of the things that was kind of really highlighted in some of the comments. And what was interesting, one of the comments that was filed was from the U.S. Department of Agriculture, the USDA. So they filed comments on the D&D rulemaking, kind of specifically adding some information on this required billing information part and some of those timelines. So I thought that was this was a really interesting rulemaking and certainly comment period, because we've seen the DOJ, the Department of Justice, and now the USDA commenting on this FMC rulemaking. It's just so cool. So the USDA, Department of Agriculture, said that they actually strongly support the D&D rulemaking effort and suggested a few recommendations for modification. They did say that, this is a quote that I'm going to read from the actual comments, but agricultural shippers have long expressed concerns over unfair and incorrect demurrage and detention charges. Charges often billed in error or when delays were the carrier's fault. Shippers have also decried the poor dispute resolution services offered by billing carriers. So basically they're saying, look, we hear you. Our shippers are saying the same thing. Our ag people that are using and discussing and talking to the USDA, our shippers are saying the same thing, that this needs to be cleaned up. But they said, look, we have some recommendations on how to better support this rulemaking. So they think that the final rule, USDA said that they think that the final rule should apply to NVOCCs and MTOs. So those are the ports and the non-vessel owning operating common carriers, in addition to the VOCCs, the common carriers. There's some back and forth on who thinks, it should be applied to all versus some. I don't know. It'll be interesting. I think it's probably going to be applied to all three. I think the NVOs, the MTOs, and the VOs are all going to be part of this final rule. They'd have to be pretty specifically carved out with kind of their own set of rules. But yeah, I don't know. We'll see how that shakes out. But so the USDA also said that they support required billing information and required billing timelines, but they suggested adding the shipment's transport history to the required billing information. So, they basically said, look, we need to be able to look at where it was, what it was doing, to enhance and help verify the transparency around free time, availability, and earliest return date. I think that's pretty good, pretty interesting. USDA also suggests that the invoice be due to be paid within 30 days of delivery, unless it is disputed. So USDA was a little bit unclear, I feel like, in their comments. Go take a look at that yourself. But the invoice be due to be paid within 30 days of delivery, unless it's disputed. Okay, they also said that they suggest allowing a new 30 days for the correctly billed party if an incorrectly billed party received the invoice first and disputed it. So I think that makes some sense. And this is where, like I said, it was getting a little bit confusing, 30 days and who they're talking about in their comments. But this makes some sense. They're basically saying, look, if that invoice goes to the wrong party and they file a dispute and they're like, look, you filed it to the wrong people, they want to afford for some of that fairness so that the billing party can send it to the right person. And they're not like, by the time that gets figured out, it's day 45. They don't want to say, oh, nope, you sent it to the wrong person, you're screwed. They're basically saying, look, now you have new 30 days to send it correctly to the correct billed party after it went to the wrong party. I think that makes some sense. That's really getting into the weeds, but I think that makes some sense. You want to make sure that you're sending it to the right party, but there's a lot going on. There's a lot of invoices coming and going. This is just part of that cleanup stuff. I just think that's interesting. I think that really reflects notions of fairness and really what this whole exercise is about. The 30 days to file a dispute or the 30 days back and forth, it's interesting. Like I said, it gets a little confusing. I think that you should take a look at this. If you're interested in the 30 days back and forth, see what the USDA has to say here. It's only 2 pages. Their comments are only 2 pages long here. I think that it is pretty interesting in what they're talking about. Really interesting in kind of, how they're kind of trying to apply it all and what they're looking to change. But I think that correctly billed versus incorrectly billed, I think they're onto something there. I think the FMC is going to take a look at that. So, like I said, that's the only comment we're going to be covering today. I'm getting back into it. Follow me on LinkedIn to kind of see. I'm going to be posting my kind of brief snippets of what I'm finding in the comments. There's almost 200 comments. I'm not going through all of them, but I'm going to, as I come across really interesting ones, put them up on a post. I have it kind of on a hashtag D&D_comments. If you want to kind of follow along, you could follow that hashtag, I guess. But yeah, keep up to date here. If I find really interesting ones, I'm going to work them back into my By Land and by Sea weekly posts. But as always, the guidance here is general and for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. But if you have specific legal questions, feel free to reach out to me at my legal company, Squall Strategies. Otherwise, for the non-legal, e-learning, and the general industry information and insights, come find me at the Maritime Professor. If you like these videos, let me know. Comment, and share. If you want to listen to these episodes on demand, or if you missed any previous episodes, check out the podcast By Land and by Sea. If you prefer to see the video, they live on my YouTube page, By Land and by Sea, presented by the Maritime Professor. And while you're at it, check out the website, maritimeprofessor.com. E-courses, they're coming, they're dropping soon. I've recorded some of they're looking so good. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.